Okay, Wendy. Well, welcome.
Thank
Welcome.
you.
Nice to see you again. It's a very interesting topic we've got this week. So let's start with this listener's experience of falling in a supermarket, which led to us to explore the issue of when a company can and can't be held liable for your medical and other expenses related to such an in-store accident.
What prompted this discussion was an email we got from listener Colleen Godfrey, who contacted us about a fall that her 80-year-old husband Neville had in Pick n Pay's Lakeside branch back in January. He'd walked to the store, as he's done many times, on his own to buy bread and milk. And apparently, Colleen has seen the footage, and obviously Pick n Pay has seen the footage. Apparently, he can be seen from the footage that, the camera's trained at the entrance from the inside. He's seen leaving the store, and then a few steps beyond the store entrance, he does an about turn as if he's forgotten something. He then re-enters the store, goes out of camera view, and moments later, exiting the store for a second time, his foot hits a basket stand. You know, those stands of baskets that supermarkets have at the entrance somewhere. And he falls. He was helped up by a woman security guard. It apparently appears to say, I'm fine, and leaves almost immediately. Colleen says that on arriving back home, he was confused and told her that he'd fallen in the store, but he didn't know exactly what had happened to cause the fall. And he was worried about his knee, as he'd had a replacement a few years previously. Okay. Over that weekend, Colleen says, he developed an extremely sore chest with shortness of breath, and their GP confirmed that he'd broken 3 ribs.
Wow.
Poor things. She prescribed pain medication. There's not much else you can do other than just let them knit
heal.
Or whatever the word heal on their own.
You can't do anything with a cracked rib.
No. So, 3 and a bit months later, he's doing much better. Colleen told me this morning. But, if they go over a bump in the car, it's still sore for him.
Listen,
so
a cracked rib is a painful
totally
thing
there.
to have. Yeah.
Yes, 3 of them.
Just breathing is difficult.
In the beginning, sure. So Colleen approached the store because she wanted to know what had happened since her husband wasn't sure. She was initially told no one had fallen, and she was concerned that there'd been no incident report filled in. Eventually, the incident was confirmed, and the security footage, as I said, was made available to Colleen. It's quite a long, involved story, but she says a woman who called her from Pick n Pay head office annoyed her because she made it very clear that all she was worried about was whether the company was liable or not. And in part, you can understand that, but the people involved are looking for a human reaction, not a legal one.
Exactly.
And that and the stores are trained to think about these liability issues because it's a situation that they face often, and there are very big legal implications. And so I think this often causes upset because the person who's fallen or their loved ones are expecting compassionate response, and the stores are sort of mostly trained in certainly at head office level to minimize any liability. Right. So
they're talking at cross purposes.
Yes, often. So the reason Colleen emailed us was because more than 2 months after those initial discussions had passed, she said not a word had come from anyone either at Lakeside or head office. She says if someone enters a store and falls, regardless of the injury, such an incident report should have been compiled, she says. And then she says, we noted that the stand of those baskets had been, a table or stand had been placed next to the basket stand. So one has to now walk around it to exit the store from that specific counter. The medical costs were fairly low for this sort of incident, around 3,000 Rand, some of which was settled by the couple's medical scheme. But I think more than anything, as I said, Colleen wanted someone at Pick n Pay to express basic concern about what had happened. So we took up the case with Pick n Pay. Their response was that should any incident occur in a store, Pick n Pay's priority is always the well-being of its customers. We follow our standard incident procedure, which includes completing the necessary reports, investigating the incident by viewing CCTV footage, and obtaining the necessary statements, and finally reviewing the medical documentation provided by the customer should a claim be required. And so in this case, she hasn't commented on this specifically, but Neville quickly got up with the help of that security guard, appears to be assuring them that everything's fine, and leaves. But as Colleen says, often, there's adrenaline coursing
Definitely,
through the
you're in
person's body,
shock,
and you're in a little bit of shock.
A little embarrassed, you want to get out of there.
A little bit embarrassed, exactly, right at the entrance to the store. And I think that's probably what happened in this case. So I think the point is fair, that the person should always, be invited to sit down, take a breath, let's get your details. And even if they say everything's fine, especially in an elderly person, that they should, be brought a chair and be made to go through those procedures. So Pick n Pay continues. Our customer services liaison remained in contact with the customer following the incident, and it was advised that he was doing well. We also offered to cover any medical expenses should treatment be needed, which is not something that Colleen mentioned in her original email to us. And we shared the process for submitting the relevant documentation. To date, we have not received any medical reports. However, following your inquiry, we have reached out to the customer again to request these so that we can proceed with the incident process. I spoke to Colleen this morning. She's busy compiling the documentation. She called herself a BC before computers. She's in her 70s, and she's going to need her children's help to sort of get information off of apps and that kind of thing, which we can fully BC. Understand. Yes. So in this case, we can't pronounce it, as an independent third party, that liability, whether they were the placement of that stand was a failure to take proper care on behalf of their customers or not. That's not for me to say. And I think in this case, when it's such a low quantum, most supermarkets would just say, we're terribly sorry, this is a regular customer, and let's see how we can help you make up any shortfalls or whatever with your medical expenses. So it's in cases where the injuries are far greater, with a possibility of long-term injury, damage, and that kind of thing, where the whole legal issue becomes a far bigger deal.
Yes.
But we thought it was a good idea to look at this issue from all sides: liability, customer service, how companies should respond, and what you should do if it happens to you. So slip and fall injuries usually happen as a result of flawed surfaces, slippery floors, and other dangerous conditions. They mostly happen in shopping centres, convenience stores, supermarkets, restaurants. According to personal injury law firm DSC attorneys, in South Africa, liability for fall in a store is determined by the principles of negligence. So it requires the person who falls or slips to prove that the store owed them a duty of care, that they breached that duty, and that it was that breach which directly led to their injury. So if a store owner has taken reasonable steps to prevent foreseeable accidents, they are unlikely to be liable. So, for example, if a customer, many years ago, a personal injury attorney explained this to me. If a customer drops a bottle of oil in aisle 3 and within seconds a fellow shopper, unaware of what just happened, slipped in it, fell and hurt themselves, the store would be unlikely to be liable if it proceeded to a court case, given that they hadn't had sufficient time. It wasn't reasonable to expect that in a matter of seconds that they could have got a cleaner there, demarcated the area.
I've slipped on a bag of sugar before in a supermarket. Yeah. I don't know when it was dropped, but so that I can relate to.
There you go.
Yeah.
If, on the other hand, the oil spill had happened, say, 5 minutes earlier, before that second shopper fell in it, it could then be argued that the supermarket management had a reasonable amount of time to protect other customers from slipping in the hazard, but failed to do so. And I mean, you often hear in supermarkets, that a PA announcement, can a cleaner please get to aisle 7? Because that's why they have to limit liability. If they can be seen to have found not to have acted quickly enough, then they would be liable.
So the countdown starts as that bottle breaks.
Exactly. Yeah. Exactly. So in other words, the store's actions or inactions must have fallen below the standard of care that a reasonable store owner would have taken to prevent another customer falling, in order for them to be deemed negligent. And there must be a direct link between the breach of duty and the injury, such as failing to maintain the floors properly, not taking care of a loose tile that somebody could then trip on and fall. So what do we look at it in terms of compensation in these slip and fall cases? So there would be obviously medical expenses, pain and suffering, and loss of earnings. But DSC attorney says it's only worth proceeding with a claim in the case of serious injuries that are considered chronic, life-threatening or crippling, or that lead to a loss of income. That's an important one. And that will in most likely incur a lot of medical bills in the months and years ahead. So when claims are reasonably small, as in the Godfrey case, as I said, supermarkets tend to settle, on presentation of medical bills, and they most likely ask the person to sign that, it's received in full and final settlement, because they'll want to protect themselves from any further claims down the line.
From the press and being outed as being uncompassionate, maybe.
From the person that had the fall, they want to shut down any possibility that in 3 years' time they're going to come back and say, well, actually, I've got a pain in my neck and it must be due,
yes,
that kind of thing.
Yeah, it makes sense. Often we go to the manager and say something's broken in the thing aisle, or
you know, you should do it as an email. I would say
it has to be an email,
of course,
right. In writing.
Yes, absolutely. So then we come to,
if it happens to you.
Yes, if it happens to you. So obviously the first thing would be to get proper medical attention if you need it.
Yes.
Because otherwise your minor injury could develop into something a bit more major. And more than that, you need proper medical records to support, if you're making a legal claim for damages as a result of a fall, then you need those records to back you up.
X-ray and all those kind of things. Yeah.
If you can, and this is really important, take photographs. It's helpful if you're with someone when it happens, because you're a bit dazed and confused and shocked.
Yeah.
And it's quite hard to do all that yourself in such a state immediately after the accident.
It's true.
But if you can do that, if someone's with you, then take photographs, because you need to, the what you fell, how you fell, the placement of the hazard is very material in terms of whether the company is supermarket or restaurant or whatever the case may be, it was negligent or not, in not preventing or not taking care of that potential hazard. So being able to prove by means of photographs, yes, there's mostly CCTV footage, but it's in the hands of the company, and the angle might not, the angle of the cameras might not cover the actual spot where you fell, and there's all sorts of...
So immediately take photographs for evidence.
Or ask a passerby to do it for you if you can't,
Okay,
that's
good
very,
advice.
very important as evidence. And then if you decide, if it's clear that your injuries are significant, and that you could be out of pocket, not just medically, but in terms of loss of income, don't discuss the case with anyone other than a personal injury attorney, or whoever your attorney is, if they're willing to take on a personal injury case. And don't sign any documents, rather, that you are asked to sign relating to the accident without first discussing it with that attorney, or if you're not going to hire an attorney, someone in your circle who's proficient in dealing with these sorts of matters. And then finally, I thought, I did a deep dive in this issue, and because I found it fascinating. And I found a piece of advice from Webber Wenzel attorneys, which was advice to companies with regard to how to handle these slip and fall incidents, so-called slip and fall.
Okay.
And it went like this. The best way for clients to avoid the most severe legal consequences of a slip and fall incident is to foster an approach that emphasizes prevention and treats a disclaimer sign as a risk mitigation measure rather than an impenetrable shield against liability. In our experience, the clients most likely to be adversely affected by slip and fall incidents are those who overemphasize external risk mitigation rather than detailed focus on day-to-day operations. So essentially he's saying, don't just think that you can slap a disclaimer notice on the wall and think that you can't then be liable for injuries suffered by a customer if they slip or injured in some kind of way, that whatever happens, you can point to the sign and say,
I told you it's dangerous.
Or we're not liable. It doesn't work like that. So you have to manage your environment on behalf of the customer. So if it was taken to court, these are the questions that you'll be asked. Do you have a good relationship is there a good relationship between management and staff? What security measures exist to provide objective evidence if the incident occurs? So obviously, they're talking there about CCTV. How often is maintenance performed inside and outside the premises? You'll need to show your records there. And Web Wenzel says proactive clients stress test their facilities for slip and fall and operational liability through engaging in the services of a workplace inspector that specializes in health and safety. So essentially, you've got to do an objective assessment from an external party point of view to reveal the blind spot that workers and management may not be aware of to snuff out highly preventable liability. And I thought that was great advice. So don't just rely on that sign. You've got to actually be very mindful of how safe or otherwise your environment is for those who are visiting your clients.
Absolutely. And I think also what you mentioned about staff training is so important, because if you can immediately approach the person who's been injured with a gentle, compassionate approach, immediately their guard
is down.
Exactly. And you feel like
you feel safe.
Like you're being cared for.
Exactly.
And then you might not feel so hostile to retaliate,
Exactly.
Yeah.
So in this particular case that we started off, I mean, you could see the security guard immediately rushes over, but I think, letting the guy say, I'm fine, and leave. And she was probably not trained to deal with that. She was just, it was
not her fault.
A compassionate response. He said, I'm fine, and left, and that was it.
She was being human.
Yes,
Okay.
So I thought some really, really interesting advice there. I've had quite a few cases come to me over the many years that I've been doing this. I remember once awful case where a woman was in a major retail store in Durban, and there was a shop employee on one of those very tall ladders stocking the top shelves that we customers can't reach without help.
Definitely not me.
Nor me. And this shop employee dropped a boxed fan, pretty heavy, on her head, and she fell, and she wasn't too bad at the time, but developed terribly immobilizing neck injury. As you can imagine, there was some kind of compression, and then all the legal thing happened. I can't actually remember how that one panned out, but I took it because she felt the company hadn't done anything, and so it went on. And I've also dealt with cases where people have informed me where in supermarkets where they've had a slip and fall. And quite with quite major medical expenses ensuing, and they were settled magnificently without a question. Present us everything. So I think there are many cases where it's handled beautifully, but I think it's useful for we consumers to know where we stand, and that how the liability thing works. Because if you just trip over your own feet, or you trip over something that's where it's supposed to be, you can't have an empty shop floor. There's got to be obstacles. You can't, just because it wasn't in your own home, you can't then say, well, you've got to pay. It needs to be, liability needs to be proven.
So here's a WhatsApp that's come through just before we go to news headlines. I want to get it in. I slipped and fell in my local Pick n Pay in Table View, fracturing a vertebrae in my back.
Serious.
Shame. And the company paid all my medical bills without any quibble.
Yeah.
The staff were also really caring when it happened, and that's from Sheila. That's lovely to hear.
Very well timed, Sheila. I was just saying and I hadn't had sight of that. There are many cases where it's handled really well. They equipped to deal with it, and their legal teams know what to do. So
thank you for that, Sheila. It is good to know that the retailers are actually being caring and compassionate and helping you, and there was no quibble. So that's fantastic, and we hope that you're okay, because that's quite a serious injury, fracturing a vertebra.
Indeed.
Thank you for sending that message, Sheila. Something we're also going to be looking at now is food poisoning, and if you eat something at a retailer, can you hold them responsible for your medical bills if you get very sick from eating their food? And how do you prove that it was in fact their food that made you sick? We will be talking with Wendy about that. Wendy, have you had any questions like that about food poisoning before?
Oh yeah, I wouldn't say it's every month, but I get a steady stream of them.
Yeah.
And I think what a lot of people don't understand is that there's unless the restaurant, I mean, this could be a sit-in situation, or it could be a takeaway you ordered, or it could be a ready-made meal that you bought in a supermarket, for example.
Yeah.
But the burden of proof on you to prove that it was that particular food that made you ill is quite great. So in your moment of not feeling well, and expulsion is a really good word, whichever orifice it's coming out of.
Oh, my word.
You need to have the presence of mind to save some of that, and then also to have, if it's a takeaway, you would probably, even if you threw it in a bin, you have access to it if it was still there, or you would have had a takeaway, but you would then need to go to a lab, and the lab would have to prove that the bacteria, the microorganisms in your bodily substance was the same one that was found in that food.
In that morsel.
Yes, because otherwise there's no direct, I'm sure, in many cases people are right about what made them ill, but the point is you could have eaten or drunk, it could have been something else. There could be it could be a bug, it could be a lot of things. And look, in some cases, I remember, I just Googled it during the break. It was as long ago as 2018, and an upmarket Durban restaurant, a bistro-type restaurant. There were more than 10 people who fell ill with salmonella poisoning. Salmonellosis, it's called. Okay. Salmonella being the bacteria.
Yes.
And it was linked to, that all had some form of Hollandaise raw egg kind of sauce, which the restaurant had stopped making in the house and had got a supply in.
Okay.
And someone ended up in hospital, and the restaurant admitted it, and obviously the legal issues took their course from there. But so in some cases, and I mean, with social media now, it's difficult for restaurants, especially busy restaurants, served a lot of the offending food.
Yes.
The word's going to get out, whereas pre-social media, it would have been harder for people to prove.
Yeah.
But unless the restaurant admits it and doesn't require you to have scientific evidence, and I've had many cases, and I've seen, people accusing mostly fast food outlets. You made me sick. I want compensation for, I missed 2 days of work. This is the medication I had to buy, and here's my doctor's bill. And the lawyers for these big companies come back and say, well, there's no established link. It's hearsay.
You have to have that laboratory
you have to
evidence.
have the lab proof if called upon to produce it. Okay. And I think a lot of people don't realize that. It's easy to say, to make the allegation, and in your gut, figuratively and literally, you may feel that you know exactly what made you ill, but you need to be able to prove it.
I mean, often people can be hospitalized for
yes,
salmonella
in the
poisoning.
case of that salmonellosis,
yes,
from the Hollandaise sauce, quite a few of them were.
It's quite a mouthful.
But just to put, I know, I'm quite impressed with myself for getting that right. If there's any food scientists saying it wasn't right, I apologize. But yeah, I think also be very careful about making these allegations on social media, because it's not defamation if it's true and in the public interest, but you only know for sure that it's true if either the restaurant admits it or you've got lab proof.
Yeah.
And without it being true, it's defamation, and the company could decide to come after you, and increasingly
could
they
backfire.
are.
Yeah.
So just a word of warning about that.
I think in general on social media, be careful of any accusations.
If you can't prove that it's the absolute truth, rather don't say it.
But perhaps there's a CapeTalk listener out there who has had food poisoning and taken it further with a restaurant or the establishment that they ate at. Maybe they were wise enough to get lab evidence. We would really like to hear from you. Tell us what happened. Did the restaurant, I don't know, offer you a free meal, or did they pay for your medical bills? We'd really like to hear from you on 021 446 0567, or you can give us a WhatsApp, send us a WhatsApp on 072 567 1567, or a voice note to 072 567 1567. Any other questions you might have? We are an open line now for the next 15 minutes up until the 3 o'clock news. Once again, 021 446 0567, 072 567 1567 are our numbers, and it doesn't have to be about food poisoning. It can be about anything that you're dealing with in the consumer market. And here we go. here is a question. It's a doctor called to say that food poisoning is a notifiable disease. No? Did that happen? Oh, that's actually Max telling us that a doctor called in and said that food poisoning is a notifiable disease.
There you go.
Okay,
Yes,
I realized
important
that.
to say. Yes.
Okay, and then
because of your outbreak situation.
yes, exactly. And then I've just my studio line just went down, but I did manage to read the question before it went down, and it was about an iPhone voucher. A listener sent a WhatsApp in saying we had iPhone vouchers. We couldn't think what we wanted to buy, and then when we decided what we wanted to buy, they had expired.
Oh, do you remember? Did you remember? Did the listener describe the circumstances under which those vouchers were issued?
Max, did they say that? No, they didn't.
Okay, so there's a very big distinction between a prepaid voucher and one that is issued by a rewards program, for example, or as compensation for, say, bad service or late service or whatever, which does sometimes happen. So it's only the former that the Consumer Protection Act regulates.
Okay.
And so it is, if I buy you a voucher for a spa treatment, Bianca, and that under those circumstances, they cannot, as they used to in the past, say it's only valid for 3 or 6 months. It needs to be valid for at least 3 years. Okay.
Oh, really?
Yeah. But in the case of vouchers issued under other circumstances, as a perk, as a sorry, that kind of thing, there wasn't an actual monetary exchange for it. The supplier or the issuer of that voucher has full discretion to impose whatever validity period they deem appropriate. So if it was the latter, if our listener was issued those vouchers and it wasn't a straight paid for in full upfront, like there's an iPhone voucher to the value of 10,000 rand or whatever. If there was no monetary exchange for that, specifically for that voucher, then it doesn't have to be valid for 3 years. You don't recall what the validity period was?
They didn't say. They just said they had iPhone vouchers, and then they couldn't decide what to buy. And then when they did, I don't know how many years it was, but
or months, could have been months.
Yeah.
If it was over 3 years, and it was a prepaid thing, unfortunately. And this is, I would love to know how much the value of each company's unclaimed vouchers, because I think it would be significant.
I would imagine, especially for iPhone. Okay, we've got a caller on the line. It's Andrew, and he has a question about his business class ticket that he bought. Andrew, can you hear us?
Yes, I can.
Thank you for calling in. Welcome to Cape Talk. What is your question for Wendy?
Yeah, thank you. I bought a couple of business class tickets a couple of months ago, and they, in the normal circuit, and I've traveled with Emirates a few times, normally we're able to pre-book our seating arrangements, and it includes a service to the airport, and it includes the airport lounges. Now, when I received the e-tickets, there was no correspondence prior to that, by the way, with the travel agent. And when I received the e-tickets, there was no indication of any problems with them. But when I tried to book our seating arrangements, I couldn't do it. I then went back to the agent, and he said, okay, he would try. And I also posed the question about, did the airline still do the transfer service? He said, yes, they do, and we qualified for it. He came back and answered that. But he said he could not do the bookings of the seat bookings. So I went into Emirates, and they told me suddenly, no, this is a special price ticket that does not include any of these extras. Now, that was certainly not made clear to me or to the travel agent's their personnel. And so I had a word with them and said, look, I felt that they should either reimburse me with my money, or they should pay the difference in price, which happens to be 51,000 rand to increase to update that to a full business class ticket. Now, I just feel that is wrong. And
I think, Andrew, it sounds like a case of lack of disclosure on your version, that you weren't aware. So please clarify, you would have to pay an extra 51,000 Rand. Yes, it is a business class ticket and they're very pricey. You would have to pay an extra 51,000 Rand to get what exactly?
To get the normal perks, as in being able to pre-book your seats, the particular seats, get the transfer service to the airport, have the use of the airport lounges.
Okay, so you feel that the ticket was downgraded, or that you were somehow quoted for a ticket without the usual perks, without them disclosing that to you. And I think that if that is the case, then that's, I mean, how many times had you bought a ticket, business class ticket, and had those extras?
Oh, numerous occasions.
Okay, so it was a material change. And did the agent say that she booked you on a less premium business class ticket, if there's such a thing? No.
In this case, it's a he.
He, right.
He also was under the impression that we had booked normal business class tickets.
Okay, well, that is I mean, if the agent doesn't know, how are you supposed to know? I would love to, if you could send me an email outlining that, Andrew. I will send it to Emirates media people and see what they come back with.
Super, thank you. Well, the agent came back to me this morning with an email saying that neither Emirates nor the travel agent themselves would be interested in it. They would only they would waive the administrative fee, but I would still have to pay the upgrade.
Okay. Well, let me see what the media people come back with, because I think if it happened to you, it could happen to others, and disclosure is very much required in these sorts of transactions. So, yeah, I'd like to investigate and get their side of the story. So if you could send that email to me at consumer@knowler, knowler.co.za, that would be great.
Super. Thank you kindly.
Thanks,
Thank you, Andrew, for your call. Thank you for calling in today and sharing your problem, because every problem will help another
That's
person.
Exactly. When I get if I should get a similar complaint, I will be able to advise accordingly.
There's a question that's come through on the WhatsApp line. What happens if you fall in the street and break a bone? Is the city liable?
Absolutely. Trying to go legal with most municipalities in this country would be an exercise in futility. I guess, but perhaps not. So yes, they would be responsible if there was a sidewalk and a paving stone was very much, had come up and was a tripping hazard, or there was a manhole cover missing, a fall hazard, potholes. So, I mean, I've been doing this for 27 years. So back in the days when there were fewer of these issues, the maintenance was better. And I would say to people, as I advised in terms of other hazards on non-government land, to report it, because then it can then be said later that the company was negligent in not fixing it. And those days, I would say report the pothole, because then they're negligent if they don't fix it. But I think things have got in many municipalities have become crazy. But yes, technically, legally, if you have the if you have the stomach for a fight on the score and perhaps some legal fees, budget for legal fees, they can most definitely be tackled on, if the hazard was there for weeks or months, they did nothing to repair it, and thus they were negligent.
I mean, the other day I was walking up a hill near to my home, and there was one of those for sale banners that were sticking out from a wall. And
a real estate agent.
Yeah.
Okay.
They put it out in a sort of 3D way, so that when you're driving past, you get notified. But I saw that someone had stuck on it, "Mind your head." For me, it wasn't a problem because I'm pretty small, so easy. I walked under it without even noticing. I didn't even notice.
You see, it's advantageous.
But someone
taller
must have hit the head, because they had stuck the note, on it, saying. So in that case, I would imagine the real estate agent could be.
I would say so. Yeah. Yes.
We've got a voice note from Felicity. Let's hear what she has to say there, Obi.
Hi there, this is Felicity from Meadow-Ridge. I'm just phoning to give Wendy a backpack because just to let her know that her name has got a lot of clout. Recently, I had to have my geyser replaced, and the plumber, when they arrived, bashed into my carport and damaged it. And from then on, it was terrible to try and get them to fix it, and it was dragging on and on
I
and
get
on.
a lot of these.
Eventually, I got to the point when I'd had enough, and my next port of call was going to be Wendy. Fortunately, the assessor phoned me that morning, and I said to him, if you hadn't have called, my next port of call was going to be Consumer Council and Wendy Knowler. Well, literally 3 hours after he hung up, things started moving, and everything was concluded and fixed and well done. But kudos to Wendy, unbeknown to her. Bye.
We call
I
it
love
the,
helping that way without lifting a finger.
I
Thank
love
you,
it.
Felicity, for that.
We like to call it the Knowler effect. If you do want to send an email to Wendy and pull that punch, you can send it to consumer@knowler, knowler.co.za, or you can contact her via Facebook on her Facebook page, Wendy Knowler Consumer. And please put Cape Talk in the subject line and 1 or 2 descriptor words so that she can have a look if she would like to take on your case.
And I have to have my own disclaimer is that I get far more emails than I could possibly deal with. So
Yeah.
apologies in advance if I don't respond or don't take up your case. I just the volume is far more than one journalist working alone can deal with, and that bothers me greatly. But it's a reality I can't really do anything about.
But we appreciate all the work
Thank
that you
you.
do. So thanks for that, Wendy. And thank you to Felicity for sending in that
Oh, that's
beautiful voice
delightful.
note, which I first thought she said she was going to give you a backpack.
I
but
did
then
too.
but then I realized that actually in that
Pat.
backpack was a lot of praise. So well done to you too, Wendy.
Thanks,
it is now
Bianca.
time to take some ads. Thank you so much for all your calls today. And thank you, Wendy, for
Thank you.
that fascinating talk about whether you fall in the store and who is liable or who is not.